عودة مرة أخرى مستمعينا إلى الساعة الثانية من برنامج الرايت مع المحامية جومانا كيروز على الهواء مباشرة عبر سينا 1.3 FM. للمشاركة معنا في البرنامج بإمكانكم الاتصال على الأرقام 313-769-6666 و 519-256-1023. أما رقم الهاتف في مكتب المحامية جومانا كيروز 248-557-3645 لكافة قضاياكم المتعلقة بالإصابات الشخصية، من ضمنها حوادث السيارات، إصابات العمل، وقضايا الانزلاق والأخطاء الطبية. 248-557-3645. جومانا، نرجع لك مرة ثانية.
مساء الخير كمان مرة رامي، ومساء الخير لكل المستمعين. كيفك رامي؟
أهلا وسهلا جومانا، نرحب بيكي وأكيد سعداء بلقائك مرة ثانية في الساعة الثانية من برنامج Your Rights.
شكرا جزيلا رامي. ونحن اليوم أنا سعيدة جدا أنه بدي استضيف معي محامية للوصايا، المحامية مالوري يلدو، اللي هي موجودة معي هون بالاستوديو. المحامية مالوري يلدو اختصاصها الوصايا Estate and Trust بيقولوا لهم بالإنجليزي. بتفهم شوي العربي، بتتكلم الكلداني، هي من أصل عراقي. بس أنا اليوم وقت اللي هي رح تحكي رح أخذ شوية وقت وقف وترجم. موضوع الوصايا شغلة مهمة جدا جدا جدا. أول شيء رح رحب فيها ورح أسألها سؤال ومن هون رح ننطلق. First and foremost, I am so happy to have you here with me, Attorney Mallory Yeldo. Thank you for coming.
Thank you for having me.
It is a pleasure. I know it's a busy Monday. Thank you for accommodating. We are very happy to have you. It's important that we share with our Middle Eastern listeners the importance of everyone, whether they are rich or poor, doing certain things to protect their families after they are gone, to protect their children. So I want to begin by asking you, Mallory, does everyone in the state of Michigan have a will? هل كل شخص في ولاية ميشيغان عنده وصية؟
Surprisingly, the answer to that is yes.
Okay.
Because whether they have created one themselves or they have not, the state of Michigan, if they have not created one themselves, the state of Michigan has actually created a will for them.
Okay, so people who are listening, some of them have gone to estate and trust attorneys like yourself, and some of them have not gone. But everyone, me, you, people who are listening to this for the first time, they already have a will through a law here in Michigan that says that when they pass, when they die, everything they own is to go according to what Michigan law decides for them.
That's correct.
Okay. So let me ask you, let's say, nowadays you have blended families. You have people who are married and they have children and then they divorce, they remarry, and maybe they have children together, maybe they don't have children, and maybe they have children from another marriage. If I were to ask you right now, a couple who's listening who does not have their will written, but their will is written for them by the state of Michigan. And very specifically, the law that we're talking about is Michigan Compiled Law 270 or 720. That is a whole code in Michigan called the EPIC code, which has to do with estates and trusts. So let me ask you, if somebody's listening who did not write his will, he has 2 children from a former marriage and is married now to a wife and she has 2 children, but they don't have children in common. He leaves, I don't know, $500,000. Who gets what?
In that case, the spouse gets around the first $150,000. Then from there, the remainder gets split between this spouse and his children, his biological children.
Okay. Do her children inherit anything?
No.
Okay. So if somebody did not write their will and is remarried, the first $150,000 goes to the new wife. Then whatever is remaining is half also to the new wife. So she ends up getting more than half. Half plus 150,
yes.
And the other half are for his children. What if somebody just got married a month ago and, loves his new wife, but I don't know that the trust is there yet. Are you telling me that that person a month after she marries her husband is going to walk away with more than half and his children from his first marriage will take the rest?
Unfortunately, yes.
And what if that's not what he wants?
If that's not what he wants, then the most important thing he should do is create an estate plan beforehand to ensure that what he owns goes to the people he intends it to go to.
What if this man does not want yet or does not want to leave anything for his new wife? Can he write a will where he excludes her and give it all to his children?
So technically, he is able to provide for his children. When it comes to completely excluding a spouse in the state of Michigan that he is legally married to, that gets a little bit difficult.
Okay. So, but he can work toward that in a will.
Yes, he can definitely determine what percentages and how he would like his assets to pass. And he has control over that rather than allowing the state of Michigan to control that.
So if he doesn't do anything, his newly married wife 2 weeks ago is going to get a little bit more than 50%. If he doesn't like that, he'd better have gone to an attorney like you are to say exactly what his wishes are.
Correct.
Okay. Understood. So أول شغلة عم بتقولها المحامية مالوري يالدو إنه كل إنسان في ولاية ميشيغان ولربما بكل الولايات كاتب وصيته، إن كان هو كتبها لأنه راح عند محامي للوصايا ولا إن كان لأنه منه كتبها. ولاية ميشيغان في قانون بيسموه intestate succession، يعني وقت الإنسان بيتوفى بس هو مش كاتب وصيته، ولاية ميشيغان كاتبت له الوصية. عطينا مثل من الأمثال، شخص بعده متزوج ما له جمعتين، يمكن هو إذا مش كاتب وصيته زوجته الجديدة رح تاخد أكتر من النص، وولاده من زواجه الأول his blood children رح ياخدوا أقل من النص. يمكن هذا الشخص مش هيك إرادته، يمكن إرادته إنه يخصص ولاده بمبلغ أكتر بكتير. ليقدر يعمل هيدا الشيء لازم يكتب وصيته. Attorney Mallory Yaldo, I have a question for you.
Sure.
You know our Middle Eastern community, sometimes we like to save and unfortunately we do it in the wrong places. I have heard of people going online, and God knows nowadays with ChatGPT and what have you, you can find a sample will. Let's talk about a will. Let's not talk about a trust for a minute. A sample will that you can pull online and you can write whatever you want. Do you think that that is, I know, you may have a built-in bias here because that's what you do, but I know you're very honest. Is it ever okay for somebody to pull a will online, sign it, give it to his lawyer, or leave it with his family?
I don't recommend doing that because online forms miss key details, and it's important that a will is drafted legally in order for it to be enforceable. And I've seen in the past with clients who have tried to complete it themselves online and have missed many things. Such as even funding and making sure that, if you have a will drafted up, your home still needs to be protected. A will alone doesn't protect the house. So although their intention was to protect, everything still ends up going to probate.
That's a very big problem. Okay. Because going to probate, number one, and I'm going to translate all this in Arabic, takes time. Number two, a lawyer has to be hired.
That's correct.
But if you hire the lawyer to write your will properly, you don't need a lawyer later for probate.
Yes.
So you save a lot more money hiring a lawyer in the beginning for your estate and trust than it is to die without a will or to get it online. And now it's going into probate. You have to hire a lawyer. It's thousands of dollars. It is many, many, many months. And your entire life is exposed. Everybody will know everything, even your creditors and everything.
Absolutely. Probate court is public.
Yes. Yes. So عم بسألها سؤال كتير مهم. هل بنقدر بهالأيام كل شيء موجود على الإنترنت، هل بنقدر ناخد وصية أونلاين ونكتبها بتقول إنه هي ما بتنصح بتاتا هذا الموضوع، لأنه الشغلة مش بهالسهولة. أولا ما بيكفي وصية، في شيء اسمه تراست رح نحكي عنه كمان لازم ينكتب، مش بس وصية. هاي نمبر 1. نمبر 2، كتير أوقات الوصايا رح يكون فيها أشياء مهمة جدا وهي بتكون ناقصة، مثل البيت، مثل الاسيتس، مثل الاشخاص اللي عندهم ميديكيد ورح نحكي عنهم اني شو بيقدروا يعملوا لحتى يحموا حالهم. واذا هذا الشخص كتب الوصية الغلط وقت اللي عند وفاته، بده يروح على محكمة الوصايا، يعني probate court. هيدي محكمة غير المحاكم الأخرى. ما بيقدر، ما عنده القدرة ولا الأهل تبعه عندهم القدرة يفوتوا على محكمة الوصايا بلا ما يكون عندهم attorney، بلا ما يكون عندهم probate attorney. يعني شو رجعنا عملنا؟ يعني وفرنا $200-500 كتبناها غلط. هلأ بدنا نروح على البروبيت، بدنا محامي للبروبيت اللي بيكلف ألوفات الدولارات. والمعاناة بقلب البروبيت هي مش جمعة وجمعتين، وهي مش شهر وشهرين. On average, how much does a probate? Obviously, it changes depending on the complexity of the estate. But once you go into probate, Mallory, how long is that thing? Is that like a year and a half, 2 years?
Yeah, I've been seeing probate now taking about a year or longer.
واو يعني سنة المحامي بقلب البروبيت كورد. يعني وفرنا من جهة حق الوصية، دفعناهن أضعاف لمحامي ليفوت على البروبيت، وضيعنا وقت لأنه المحاكم تاخد وقتها. عم بتقول إنه عم بتشوف أشياء عم بتضاين أكتر من سنة. والشغلة الأخرى اللي في كتير عالم ما بحبوها، إنه وقت منفوت عن محكمة البروبيت على محكمة الوصايا everything is open. كل شيء مبين، مين ما كان بيقدر يتطلع على كل شيء هيدا الإنسان عنده، شو عنده ديون وشو عنده creditors بيقدروا يلحقوه إلى آخره. So الكتب الوصية أونلاين مش مستحسن بتاتا. وبالإضافة كتب الوصية حتى مع المحامي هو غير كافي. Attorney Mallory Yeldo, when you have clients coming, and I've seen you in action already, you never just help them draft their will. There is always a very important document that you also draft for them called a trust. Is that correct?
That's correct.
Before I ask you what is a trust and why is a trust needed, is a trust something people can also find online?
Yes, unfortunately they can.
Okay, and what's the problem with these online trusts?
So the problem with that, and I've seen that issue firsthand, is I've had a client come to me whose father created a trust online.
Yeah.
And unfortunately, he did not properly fund the trust.
Oh, so you have to fund the trust?
Yes.
Okay.
So because he didn't fund the trust, all of those assets were not protected and therefore went to probate court.
So he thought that he did the right thing by signing a will and a trust, but because it's much more complicated than that.
Yes, it is.
And again, this is not listen, I mean, we are going to share this with our listeners and hopefully we'll have you on again. Some people are still going to think that doing it online will work. And you know what? You can teach people, but you cannot. Some people are not going to think broadly. They're not going to think broadly. Unfortunately, sometimes, I hate to say this, it's a lot cheaper for you and it's a lot less headache, I promise you, to hire an attorney in the beginning than it is to fix something because you did not do it properly. I see it when people enter into businesses and they don't put things in writing, or they put them in writing but they want to save the $1,500 with a lawyer and they end up in litigation and friendships that have gone sour and so forth and so on. So this is a field where having a lawyer do this is what you really should do, because it's much too dangerous and much too costly to do it otherwise.
Yes, it is. And I've even seen in some cases with a deed that was done improperly. And
A deed to a house.
Yes.
Okay.
Yes. And when the deed is done, I mean, a house is some people's main asset.
Were you just listening to me on the radio? Because I was talking about homeowners insurance and I was telling Rami, a house is somebody's largest financial asset.
Yes.
It's their largest financial security.
Yes, and that's not something you want to take a chance with. That's something that you would rather have.
Not your largest financial asset. Absolutely
Definitely
not.
Nope. So it's best to have an attorney working with you, drafting these documents to ensure that they're drafted properly and protecting that large asset.
Your largest asset actually. So عم بتقول المحامية مالوري يلدو انه بتشوف كمان اشخاص عندهم بيوت وكاتبين الديد، يعني شو بيقولوا رامي الديد بالعربي؟
سند الملكية جمانة.
السند الملكية. شكرا. let me write this down. سند الملكية، وبيكونوا كاتبينه بطريقة غلط. واللي عم بتقوله هو اللي أنا قلته بأول ساعة، إنه somebody's home is somebody's largest financial asset. بيتنا هو أكبر asset عنا إياه بحياتنا. وعلى فكرة هالأشياء ما بتكلف مصاري كتير، عن جد كتير رخاص، بالأخص يعني وقت عم تحكي عن سند كلفية إلى آخره. بس العواقب تبعها كبيرة جدا. That's the problem. So you've seen this also with deeds. Give me an example of somebody who, I don't know, quit claiming maybe? Is that what it is? They quit claiming to the wrong person. Give me an example of a deed gone wrong that you have had to come and fix, if you could.
Sure. So I'll actually give you two examples. One with a husband and a wife.
Okay.
The husband and wife were both written on the deed, except it didn't have certain language.
Joint right of survivorship.
That's correct. So therefore, they only owned 50% and 50% of that home.
So then when the husband died, the wife only owns 50%, not all of it.
Correct.
How could you correct it after the husband died? You couldn't.
Nope, we had to go through probate.
Oh boy. So they had to hire you as a probate lawyer where they spend money for you and time in probate, and then were you able to fix it in probate?
We were able to fix it. It took some time, but we were able to finally fix it. It would have been much easier and quicker and cheaper.
Way cheaper.
To do this beforehand.
Than to hire a probate attorney.
Definitely.
So Mallory, why is it that this couple did it wrong? Did they receive wrong advice? Do you feel in our Middle Eastern community that people tell others, you don't need a lawyer, go get it online? What is it that you hear?
Yes, I think it's a bit of misinformation and also being a little bit just not knowing what is correct and the right thing to do. And that's why it's important to speak with an attorney to help guide you through these things. But I do believe there is some misinformation out there. There are some of my clients who come to me and have been told by others that they don't even need to do a will because their spouse will get everything, so nothing needs to be done.
Oh no, the spouse will never get more than 50-some%.
Correct.
Yeah.
So I do believe there is misinformation out there.
Right. And if you have young children, imagine if you leave them the other half, how are they going to manage it?
They can't, especially if they're minors.
Exactly. So, Attorney Mallory Yaldo, you always say that it's not enough to write your will. You also need to write another document called a trust. Can you define for our listeners what a trust is?
A trust is it's a legal document and a strategy that helps protect your money and your assets from going to probate.
So the will does not do that?
A will, unfortunately, still goes through the probate court process.
So then what's the point of a will? To say exactly how you want things divided?
Yes. For some people, that can be enough. However, it does go through probate, and that's why I prefer and recommend a trust more.
Okay, so let me make sure I understand. So the will tells the world how you want your money divided. If you don't have a trust with it, you're going to hire a lawyer, go into probate court, spend over a year there, expose yourself to the rest of the world. But if in addition to the will that says, I want this son to get this much and this daughter to get this much, you add a trust, only a trust will guarantee, a properly written trust will guarantee that you do not go into probate court.
Yes, and also a trust keeps everything private. Some people do not want everybody to know how they're dividing those assets. So a trust is how you can keep that information completely private.
اوكي سو لحتى نترجمها بالعربي عم بتقول انه ما بيكفي انه الانسان يكتب وصيته، وصيته فقط بتقول كيف بده يقسم ممتلكاته. هيدي ما بتكفي. اذا الانسان توفى بس كاتب وصيته، برضه الوصية بدها تفوت على المحكمة، بده يصير في محامي، بده يصير في تكاليف محامي and there are court costs as well. في تكاليف المحكمة كمان بالإضافة لتكاليف المحامي، في قعدة بالمحكمة طويلة، وفي إنه فتحنا حياتنا كلنا للآخرين. لهذا السبب بالإضافة للوصية اللي بتحدد كيف الإنسان بده يترك ممتلكاته، إن كانت كاربت ولا إن كانت بيت ولا إن كانت كاش ولا إن كانت whatever it is. بالإضافة لازم يكتب التراست. فقط التراست هي اللي بتأكد وبتحمي الشخص عند وفاته من إنه يفوت على محكمة الوصايا، يوفر تكاليف المحامي، يوفر تكاليف المحكمة، ويوفر الوقت، ويوفر إنه يفتح حياته إلى الآخرين. لهذا السبب هيدول الاثنين go together، الويل والتراست. الوصية بتقول كيف بده يشقف مصرياته، التراست بتتأكد إنه هالشي بيضل برايفت، بيضل محمي من عيون الآخرين وما بيفوت على المحكمة. Attorney Mallory Yaldo, there is a mistaken conception among our Middle Easterns, and I did talk about it in the concept also of life insurance, because a lot of people think that life insurance is only for the wealthy. Actually not. There is also a mistaken assumption that if you're not wealthy, you do not need to write your will and your trust, because you say everyone needs to write a will and a trust. These are two documents مستندين مع بعضهم, will and trust and will. Is it true that only wealthy or wealthier people need to write their will and their trust?
No, that is not true. I always say anyone who owns a home, anyone who has children, has a certain amount of money, any amount of money really, or have even won a settlement with you, needs to write a trust and a will to protect what they have.
Let's say somebody who's listening, who just works, does not own a home. It's still good to write a trust, because maybe that person owns certain things that are of value, sentimental value. A will tell the world how he wants them left, and a trust will keep it out of probate. Let's say his family fights over his card collection because it is useful or whatever it is. If there is no will and a trust, then it is then they have to go to court to fight over it.
That's correct.
Okay. So عم بتقول هي إنه أي إنسان برأيها لازم يكتب will and trust، بالأخص الأشخاص اللي عندهم يا حتى لو كان عندهم بيت $50,000 أو عندهم أطفال. لأنه ما ننسى إنه إذا هذا الإنسان توفى ومش كاتب وصيته، ولاية ميشيغان كاتبت له وصيته ويمكن ما يعجبه كيف وصيته، لنقول ترك أطفال صغار. هدول الأطفال كيف بدهم يقدروا يتصرفوا بالمصاري مثلا؟ هيدي كلها أشياء بتنكتب بالترست. أنا استضفتها للمحامية مالوري يالدو الأسبوع الماضي مع موكل من موكليني، وI watched her in action عم تسأله بالترست إنه عندك طفل تحت 18، إذا حضرتك توفيت قبل ما يصير عمره 18، مين بدك يكون مسؤول عنه لما يهدر المصاري، لما يروح ياخدها on a financial education, not on a Harley, on Harvard, not on Harley. Well, not Harvard, Yale. So I was explaining that I watched you in action last week, where with a client, you were going over his trust, and one of his children was under 18. So you did ask him, you did say that if you die before your child turns 18 and you're leaving him this much, who do you want to oversee the money so that he doesn't go waste it, on the wrong things?
Yes.
And I remember him saying one of his other children.
Yes.
Right? So again, your advice that even people who have children, even if they don't have assets, you have to have something, but everybody does.
Mm-hmm.
Everybody does.
Yes.
Everybody does. Okay. Okay, so I think we have determined that, you know, everyone, almost everyone, needs to, you know, write their will and their trust. Is there an age where people should start thinking about it? Or again, marriage, blended families, owning things, about to own things, or things of value or of sentimental value? Is there as an attorney, as an estate and trust attorney, do you give advice that after a certain age, somebody is, you know, might as well write their will and trust?
I mean, for me, of course, once you're 18 years old, you can start thinking about these things, but it's when you have, like you said, assets. Once you have certain assets, you can start thinking about planning and preparing for, unfortunately, death, or even if you're unable to take care of these things yourself, at that point, it's important to start thinking about creating an estate plan.
Okay. Attorney Mallory Yaldo, when you meet, and I saw you in action again, and I have my own estate and trust plan going. When you met with that client, you also talked about some very important things. You talked about things outside the will and the trust. You talked about some powers of attorneys. Some of them you call them medical power of attorneys. Some of them you call them durable power of attorneys. Some of them were like financial power of attorneys. Are you saying that the will and the trust is for when this person dies?
Yes.
But right now, God forbid, this person, for whatever reason, has a medical situation and cannot make medical decisions for himself. He can appoint who can make that decision for him. If he can no longer make financial decisions for himself, he can appoint somebody who can make those financial. Can you go over those, and can you explain to the listeners how a comprehensive estate and trust plan must always include these extra things for when the person is still alive?
Yes, I always make sure to include these documents in my complete estate plans for my clients because they are so important. Mm-hmm. If you think about, for example, with the financial power of attorney, also called a durable power of attorney, if something happens to you
while you're still alive.
While you're still alive, and only while you're still alive.
Right. We determined that the will and the trust, they go into action when you die. But while you're still alive, should you?
Yes, you should.
Should you have a reason for not being able to go to the bank to make financial decisions?
So in the case that, unfortunately, you're in the hospital and you're in a coma, mm-hmm. or you've developed Alzheimer's and you can't make these decisions for yourself any longer. Mm-hmm. It's important to appoint people that you trust in mm-hmm. these positions to be able to manage your money, pay your bills, run your business if you have a business.
Go to the bank and draw money.
Go to the bank, because if anyone has tried to go to the bank or even pick up the phone and call on behalf of somebody else, there is no way they're going to speak with you.
So if somebody does not write his durable power of attorney, his financial, how will the family, and they call you and they say, help, the bank won't talk to us, we're unable to pay the mortgage. How do you deal with it?
Typically then a judge would
So you have to be hired.
Yes.
You have to go to probate court again.
Yes.
You have to go in front of the judge and say what to the judge?
You have to put a claim in front of the judge showing that you can be, it's called conservator for financial purposes.
You as the lawyer?
No.
Or say the wife or the daughter?
Yes, let's say the wife or the daughter, and the judge has to determine who they deem fit to
and
act
why.
in that.
And why.
Yes.
Okay. So ما بيكفي انه الانسان يكتب وصيته ويكتب التراست. الوصية هي عند الوفاة والتراست هي عند الوفاة. بس اوقات اللي بيصير للاشخاص هن وبعضهم طيبين ظروف معينة بتمنعهم من انه ياخدوا قرارات مادية بيسموها durable power of attorney. هيدي مثل شخص صار عنده ألزايمرز، ما بقى يقدر يدفع بليته، ما بقى يقدر يتصرف ماديا. إذا مش كاتب هيدي durable power of attorney وحاطتها بالدوسيه تبعه أو بالفايل تبعه، ساعتها العائلة بدها تضطر توكل محامي مثل المحامية مالوري لتروح عند القاضي تقدم له مستند طبي لتشرح للقاضي ليه هذا الشخص ما عاد قادر انه يقوم بقراراته المادية، وتطلب من القاضي يعين شخص اجمالا من قبل العائلة. القاضي بده يقتنع، بس شو صار هون؟ صار هون في تكاليف البروبيت اتورني، صار في تكاليف المحكمة، وصار في شوية ديلاي. لهذا السبب كل البروبيت and trust attorneys، وهي واحدة منهم، بتقول ما بيكفي الإنسان فقط يكتب وصيته والترست تبعه. هؤلاء المستندين هن عند الممات، وإنما أوقات ممكن يصير عند بعض الإنسان طيب قانونيا ماديا ما بيقدر ياخد قرارات. هيدي الورقة بتحميه. بالإضافة في شيء اسمه medical power of attorney. Let's talk about that. So what is a medical power attorney? Give us an example of where it kicks in. And I assume the answer is also, if you don't have it written, you have to go to probate court, you have to pay court fees, you have to hire a lawyer, you have to make a motion from the judge, you have to bring medical records, you have to explain to the judge nobody's trying to take advantage of a family member or anything like that. So what is a medical power of attorney?
So a medical power of attorney works similarly to a financial, but this is in regards to your healthcare and your medical decisions. If you're unable to make these decisions for yourself, for example, again, if you are in a coma and you can't speak, who are doctors going to speak to? So a medical power of attorney is drafted so that you are able to name people who you trust in this capacity to make these medical decisions on your behalf.
Including life and death.
That's correct.
Including pulling the intubation if it goes there.
Yes.
So الميديكال باور اوف اتورني هي مستند آخر كمان هو والإنسان بعده طيب إذا لا سمح الله صارت صحته الطبية لدرجة إنه غير قادر إنه ياخد قرارات طبية. لازم إنسان ياخد القرارات عنه، لازم هيدا الإنسان يكون إنسان هو بيوثق فيه وبيوثق بهis judgment، بيوثق قراراته. So الميديكال باور اوف اتورني كمان مثل الديوربل باور اوف اتورني او فاينانشال باور اوف اتورني بتلغي انه الواحد يوكل محامي، بتلغي انه الواحد يدفع كورت كوست، بتلغي انه الواحد يروح قدام القاضي ليقنع القاضي لانه كله موجود. Attorney Mallory Yaldo, what other documents when somebody sits down? I heard you ask about organ donation. So I did my estate and planning, but I was not asked that question. I know they ask you on your driver's license, but sometimes you don't do it. I heard you ask that question. Let's talk about that.
Sure.
I thought that was good.
Yes. So that's for a document called a living will.
Living will.
And that goes with your medical power of attorney document. And that's where you determine what you would like those healthcare decisions to be. Similar to the life support question, also I ask about organ
those are
donation.
different. So these are different than a medical power of attorney?
Yes.
But they seem related.
They are related.
So explain to me the difference between a medical power of attorney and a durable living will.
Yes. So for the medical power of attorney, that's the document where you name the people who will serve in this capacity.
Okay.
And in the living will is where you have these specific instructions.
Okay. And if there are no instructions, the people that you named in the medical power of attorney will make the rest of the instructions.
Yes.
Okay. So بالإضافة للميديكال باور اوف اتورني، الميديكال باور اوف اتورني هو مستند فقط لتحدد فيه مين الشخص أو الأشخاص. It can be more than one person.
Yes.
It can be 2 people, it can be 3 people. So now you need a majority or something like that. So الميديكال باور اوف اتورني هو مستند بس بتسمي فيه مين هؤلاء الأشخاص اللي بتوثق فيهم شخص أو أكثر من شخص لياخدوا قرارات طبية. وإنما بالليفينج ويل اللي هو مستند إضافي بالإضافة للميديكال باور اوف اتورني، يمكن أنت عندك يمكن لأسباب for religious reason، يمكن لأسباب مثلا دينية، يمكن مثلا ما بدك إنه يشولوا الانتوبيشن إذا الإنسان مثلا بكوما وما في منه أمل. يمكن أسبابك الدينية بتمنعك إنك أو دينك بيمنعك إنه مثلا تسحب. هون بتعطي بتضيف غير أنك عينت الأشخاص، يمكن في بعض المواقف الطبية you have strong opinions about them. يعني بعض المواقف الطبية أنت بدك هيك يصير، إرادتك أنه ما ينشيل الانتوبيشن، بس يمكن إرادتك أنه الأعضاء تبعك تتوزع مثلا، إن كان لغير عالم organ donation أو إن كان research إلى آخره. هلأ إذا في أشياء طبية أنت ما فكرت فيها أو ما بتعني لك، ساعتها بالميديكال باور اوف اتورني الأشخاص اللي أنت عينتهم بياخدوا هؤلاء القرار. So the living will is a place where you say, well, for religious reasons, I don't want to be extubated because my religion prevents me from doing that. So who you named in the medical power of attorney cannot go against your wishes.
Yes, that's correct.
They cannot.
They cannot.
Okay. And maybe you did not say something about organ donation. Can those named then in the medical power of attorney make those decisions?
If you are silent on the issue of organ donation,
they decide.
They decide.
I see. Okay. So a will and a trust protect your family after you die. But while you're alive, should you have a medical problem or an inability to conduct your financial affairs, you need a financial power of attorney called durable power of attorney. You need a medical power of attorney where you name the people you trust to make decisions. And you have the right to take certain medical decisions yourself because you feel very strongly about those. And that is contained in the living will. In addition to the will, the trust, the durable power of attorney, the medical power of attorney, and the living will, Attorney Mallory Yaldo, are there any other documents that you believe one should have in order for that person to sleep on their pillow knowing that they are protecting their family while they're alive and they are protecting their family upon their death?
Yes. I want to go back to the deed. Because as long as you own a home, one property, or multiple properties, you need to have a deed for every property you own to make sure that that property is included in your trust.
So you have to mention all the homes in your trust?
No, you don't necessarily have to mention them in your trust, but you need to have a deed recorded for each of those homes or properties.
But isn't a deed always recorded? I mean, anytime you buy a home, there's a deed.
Yes.
Is there an extra step?
Yes, an additional deed has to be drafted and recorded with the estate plan to show that this house is now going to the trust after the person passes away.
Okay, so I'm a little bit confused. So I have a home and I have a deed, and I am sure the mortgage company has recorded that deed in Oakland County. You're saying, in addition to that, in my estate and trust, I need an additional deed or like a copy of that deed?
Like it's a new deed.
It's a new deed.
Yes.
New deed. And what do I do, practically speaking, what do I do with that deed? First of all, who issues that deed?
So actually, I draft the deed for my estate planning clients and I record it for them with the county.
Okay, so you draft it and you record it. So now they have two deeds for the same. So the county has two deeds on the same house?
But it's a new deed, so it cancels out that last deed. So this new deed shows one of two things. It could be a quit claim deed where it shows that the house is going from your name to your trust name.
Quit claim from me to the trust.
Yes.
Okay.
Showing that the trust is now the new owner of this
showing
home.
the trust is. Because if I don't do that, Mallory, what happens?
The home will go through probate court.
So then some things are protected, then I still have to go to court, hire a lawyer because I forgot to make sure that the deed is now quit claimed from me to my trust.
Yes. And there's a second deed that could be done instead of a quit claim deed. The state of Michigan has a special deed called a ladybird deed. And that deed allows you to keep the home in your name during your lifetime and then transfers it automatically into the name of your trust upon your death.
Okay, and that also requires another deed.
Yeah, so that it would either be a quit
It will
claim
also
deed.
cancel.
Yes.
Okay, so either a quit claim deed is one that says while I'm alive I don't own the house.
Yes.
But a ladybird deed says while I'm alive I have the house. Immediately upon my death it goes to my trust.
Yes.
This is a very important step. نعم رامي.
عندنا اتصال جمانة إذا حابة تاخذ
Yes,
اتصال.
we'll take a call. Of
31
course.
للي حاب يشاركونا لايف على الهواء 313-769-6666-519-256-1023. ألو مساء الخير.
مساء النور.
يا أهلا من معنا.
لو سمحت بس حبيت أسأل سؤال.
تفضل.
أنا عندي التراست والويل بس الكلام اللي طلع اليوم يعني كثير استفادنا من عنده. بس أحب أسأل إنه ممكن تجيب التراست اللي موجود عندي وتأخذ عليه نظرة المحامية وتعطينا رأيها بأنه كل شيء موجود مثل ما تشرحوا اليوم.
الاسم إذا بتسمح.
مو.
شكرا أستاذ مو. Mo is saying, thank you very much for the information. It's very useful and it's very helpful. And now he is wondering whether you would be willing to take a look at his will and trust to make sure that everything was done in proper order.
Yes, I do offer trust reviews and estate plan reviews.
So this is called trust reviews and estate plan reviews. Let me ask you very quickly, when you do those, like you will do for Mo, how often do you find that you need to make revisions?
I say for the average person to go back and take a look at their estate plan about once a year.
Yeah, forget that for a minute. Let's assume it was not done properly. How many of those estate and trust reviews you do where you discover that either another lawyer or the person herself or himself did not do it properly?
Unfortunately, I do see it quite often.
Oh, really?
Yes.
More than 50%?
About.
Really?
Yes.
Have you seen these? We're not going to name names, obviously. Have you seen some of those coming from other attorneys?
Yes, actually.
This is very scary.
It is, because you have put your trust into the hands of another attorney, yet some documents are not drafted properly.
Oh my goodness. Okay. استاذ مو، هل جاوبناك على سؤالك؟ بتعمل شيء اسمه Trust and Estate Plan Reviews. بتلاقي انه تقريبا 50% من الويل والتراست، شايف 50% مش مكتوبين صح، وللأسف منهم جايين من مكاتب محاماة أخرى.
ممكن يعطونا رقم التليفون أو العنوان؟
تكرم عينك، اتصل بالمكتب إذا ما في إزعاج، وهلأ بنعطي رقم بالآخر.
لا بالعكس. هي معكم بالمكتب تبعكم يعني.
هي مش معنا بالمكتب تبعنا، بس نحن عم نتعامل معها صار لنا مدة. اتصل بالمكتب إذا بدك، وخلينا كمان نعطي الرقم هلأ. Attorney Mallory Yeldo, can we give your number to Mr. Mo?
Yes. My phone number is 248-246-1888.
على فكرة خليني أرجع ردده بعد دقيقة. أي شخص بحاجة لترجمة عندها مكتبين، عندها مكتب في ساوثفيلد وعندها مكتب في تروي. She has two offices, one in Southfield and one in Troy. And I have seen her come here to accommodate our clients and benefit from our bilingual staff. So أي شخص بيحب إنه يتفضل على المكتب، المحامية مالوري بتجي لهون ونحن وفيكم تستفيدوا من المترجمين اللي موجودين بالمكتب لحتى نتأكد إنه الرسالة وصلت بطريقة صحيحة. كمان مرة رقم التليفون تبعها 248-246-1888. المحامية مالوري يلدو.
نعم.
Thank you Mallory.
جمانة عندنا اتصال آخر إذا حبيت
Another call.
يبدو أنه انقطع الخط على كل حال. 313-769-6666-519-256-1023 في الدقائق الخمسة الأخيرة. نرجع لك جمانة.
نعم، اللي بحب يرجع يتصل بليز استفيدوا، لأنه ما رح نقدر نستقبلها أكتر من مرة بالشهر. استفيدوا من خبرتها. This thing about the ladybird deed and the special deed, gee, how many lawyers miss that?
A lot. I would say that's the main
I
document.
think so. Why, Mallory?
I wish I had an answer to that question, because I would say that that is one of the most important documents, along with your will and trust, to protect that home and those properties. Otherwise, unfortunately,
That was the whole point of writing a trust, is to
That's right.
protect your biggest financial asset. I don't
Yes.
want it in probate. I don't want people knowing the value of my home. I don't want creditors. So you're telling me that other lawyers are missing the turning the deed either while the person is alive to quit claim it to the trust, or the ladybird deed that is mine while I'm alive automatically goes. So if I told you for me to check for me whether my two properties are either in the name of the trust already or are in a ladybird deed, can you find that out, Attorney Mallory Yaldo?
yes, as long as I have the county of where your properties are located, I'm able to look those up and determine if they are properly deeded into the trust or into your estate plan.
So what do you need from me other than telling you the county, my name? Do you need the deed parcel number or anything?
No, I just need name, county, and the address would be helpful as well.
Very nice.
جمانة عندنا
Yes,
اتصال آخر على الهواء.
Let's take a caller. We have 4 minutes.
شو. ألو، مساء الخير.
مرحبا.
يا مرحبا، أهلا. مين معنا؟
مرحبا، معك ندى. كيفك أستاذة جومانا؟ شو أخبارك؟ ندى معك.
يا أهلا وسهلا ندى. How are you?
حبيبتي، عرفتيني من الصوت مباشرة من دون ما تعرفي من الندى. ما شاء الله عليكي عن جد. You are يعني genius. Anyway. أنا هلا بعدني طالعة من الشغل وفتت على السيارة وفتحت البرنامج تبعك as usual. دائما بحب إني أسمع لإلك. تعرفي قديش
شكرا يا ندى.
شهادتي مجروحة فيكي، يعني عرفتي؟
Yes, I was going to say ندى الجميلة من جوا الجميلة من برا. يا أحلى ندى.
أهلين حبيبتي. حبيبتي، هلا أنا بدي أسألك، هلا أنا مثلا سنجل مام، عندي ولدين وعندي بيت ماشي، هل يفضل is it better إني أعمل ليدي بيرد ولا أعمل ويل لحتى البيت ما تروح لمثلا الحكومة ولا؟
ندى listen to me حبيبتي. الويل ما خاصة بالليدي بيرد. الويل هي بس بتقول إنه أنت حابة توزعي ممتلكاتك، بيتك مثلا لابنك الكبير مش ابنك الصغير، أو نص نص، أو إذا عندك مصاري بالبنك، أو إذا عندك عفش معين. الويل هي بس بتقولي فيها شو بدي أعمل. الليدي بيرد ديد هي بتفوت بقلب التراست. كل إنسان، بعرف حضرتك ما حضرت البرنامج من بدايته، المحامية مالوري قالت أنه كل إنسان لازم بيكون عنده وصية وتراست، تراست ووصية. ما بيكفي وصية بلا تراست، وما بيكفي تراست بلا وصية. والبيت تبعك بيفوت بقلب التراست. Let me ask her very quickly, in less than 2 minutes, Attorney Mallory Yaldo, our beautiful caller Nada, who I know personally and I adore, wants to know, is there a benefit? First of all, she thought that the lady bird is instead of a will. Nada, if you need a little bit more explaining, I'm happy to do it off air for you. More than happy to do that. But is there a benefit, Attorney? You bet, I will do that. Is there a benefit, Attorney Mallory Yaldo, to somebody having a house trusted to a house quit claim to their trust, or a house ladybird deed that gets quit claimed upon their death? Any benefit one way or another? Less than a minute.
There are pros and cons to each. Both protect the home, so that's the number one pro.
And both keep you out of probate.
Yes.
Okay. So maybe next time we need to talk about that.
Yes.
So the most important thing is that whoever has a deed has to make sure now that the deed either says it is to the trust, or it says that it will go to the trust upon passing, which is Ladybird. You have to come back in 1 month.
I will.
We are so happy to have you.
Thank you so much
again.
Thank
you for making this so simple. Thank you, Attorney Mallory Yaldo.
Of course. Thank you again so much for having me. I had a great time.
Same here. Thank you for your time.
Of course.
شكرا جومانا أكيد على هذه الحلقة الرائعة، ونشكر المستمعين دائما على حسن المتابعة. دمتم في رعاية الله وحفظه، وإلى اللقاء.